Assalamualaikum warahmatullahi wabarakatuh. And hi, my name is Muhammad Zaki bin Muhammad Zaid. My note number was 281926. So I'll be discussing with the class. I'll be discussing about question 2A. The first thing I'll be discussing is about the issues that arise from the question, and second about the rules and the laws that are relevant to our issues. So here's the question. The issue that arose from the questions, I found it four to be quite relevant. First, whether the trade names Butterfly the Bugs and Tree Fly can be accepted and allowed by Trademark Division of Malaysian Intellectual Property Corporation or my IPO to be used as a trademark for lily products in Malaysia. Second, whether the trademark Butterfly the Bug is similar to renowned butterfly mark used by the Urban Butterfly Company for their fashion products. Third, whether the mark of Butterfly the Bug would cause any problem for Lily in foreseeable future with Urban Butterfly Limited Company. Fourth, whether the trademark Butterfly the Bug and Tree Fly follows the requirements and conditions specified by the relevant statute within Malaysia to be used as a legal trade name for Lily Company products. So in general, we can say that trademark is a mark or sign that makes product different from the other products, and such signs should be distinctive character and also able to distinguish the one's proprietor from the other proprietor owner of the said trademark. So here's are the rules and the law. According to Section 13 of the Trademark Act 2019, registrar can provide preliminary advice to any marks registration with prescribed fees and information will be not made for public usage. And in Section 17, Subsection 1, any unique proprietor may apply for trademark registration if they want to utilize the mark in the market and other owners of the trademark allow such usage. The registration must be done within the time period and fees specified by registrar as seen in Section 17, Subsection 2, and such trademark that is not in English, Malay, or Roman alphabet needs a translation for the registrar usage in Section 17, Section 3, and in Section 18, Section 1, registration of trademark with multiple classification of goods and services are allowed, and such goods and services must be classified within the classification of goods and services for trademark as specified in Section 19, Section 1, and the proprietor may limit the color to one or more as been said in Section 20, Subsection 1 for the usage of their trademark. So, moving on to Section 20, Subsection 1, it says that the trademark can be rejected by registrar if sign use cannot distinguish the goods and services, not having distinctive features, trademark intending exclusive to any sign in trade, quality, quantity, GI, other characteristic of goods and services, and it is common in trade and color language. Other reason that a registrar might reject a trademark is it may cause public confusion, prejudicial to country safety, and is having similar to person name and resemble features of a country like flag, and contain common chemical names. Section 24 specifies that a trademark may be resisted if similar or equal to well-known trademark or other person product marks. In Section 34, it provides grounds for challenging a registration of a sign as a trademark. Section 35, on the other hand, provides procedure of submitting and trademark registration opposition. And in Section 39, Section 1, trademark may be registered up to 10 years and the renewal of the trademark must be not less than 6 months as specified within Section 39, Section 5. And in Article 18 of the TRIPS Agreement 1997, it says that the trademark may enjoy 7 years of protection and can be renewed indefinitely. So moving on to the cases law, in Shaifu Bahrain bin Mohamed against Exhibition M. Sinirman and Anor, the fact of this case was plaintiff was the president of PCOM and select the defendant as project executive in his company. The defendant then quit the company and built his own company with the trademark PC Expo that handles computer-related affairs. The plaintiff petitioned a claim against the defendant, arguing that defendant was using the plaintiff company trademark PC Fair, and the court held that PC Fair was a common term for the computer-related exhibition, and the name of the plaintiff trademark should be become PC Fair and not PC Fair. So next, Yong Teng Hing against Walton International Limited. The fact of this case was both applicant and respondent submitted for a listing of a trademark Giordano for a trade of leather garment. The registrar was unable to accept their request until the court ruled it out. Applicant contested that he already used the term Giordano as a trademark since 1986. In contrast, the respondent reported back that the Park trademark was first applied in Hong Kong in 1982, and the trademark itself has been given to him by Giordano Limited Company for his usage, while at the same time he also registered as the owner of the cement trademark since 1982 and started using it in 1990. So a court held in favor of the respondent, wherein the applicant did not manage to convince the court for his claim, and the term Giordano must be registered for the respondent usage. So that's all from me, and I will pass next to my partner, Auni.
Hi, my name is Khadijah Mohamed, and my mention number is 280121. So today I'm going to present about question 2A regarding the application and the conclusions of the question. Okay. Issue 1, whether true trademark of butterfly rubber regarding insecticides and triphosphate regarding plant fertilizer will be accepted by trademark divisions of Commission Intellectual Property Corporation for registration. The fundamental aspect of trademark is a sign that is registered as a legal trademark, for a proprietor must be distinctive and able to distinguish the said sign as one trademark from another registered trademark in the same market segment. For instance, local soft drink beverage maker initially cannot use the mark Coca-Cola because it's already achieved such distinctive feature has been described within Section 2 of Trademark Act 2019, as well as the mark itself are distinguishable from other soft drink brands such as Pepsi has been legalized under Section 3 of the Act. Lily presume has already achieved such a fundamental aspect of trademark, hence it should be allowed by MAIPO for preliminary inspection as curtailed in Section 30. First, we determine based on whether to mark that Lily apply for may be accepted as a legal trademark for her. Next, by looking at the marks of butterfly the bar and triphosphate, we may decide its registrability upon the requirements set within Trademark Act 2019. Both trademark, in our group opinion, follow the obligation under Section 17, in which Lily intends to use both marks for selling her product into nursery, plants, market, and other related business, intending to familiarize her customer with her product under those two brands. The sign used by her also do not encroach any provision within Section 23 and 24 of Trademark Act 2018 if we took general direction on both butterfly, rubber, and triphosphate marks, but it wise to note that it also depends upon registrar of trademark in determining whether both marks fulfill the requirement needed to be approved as registered trademarks. Lily can be a concurrent honest user of the trademark of butterfly, rubber, and even if the trademark was initially unregistered, and Lily only registered the trademark along with the triphosphate mark, she shall be allowed so by the registrar as according with Section 25. Next, to answer issue 2, whether the Lily mark butterfly the bird possesses similarity with the mark butterfly utilized by Urban Butterfly Limited for their fashion products. The mark butterfly was already been registered as a legal trademark of Urban Butterfly Limited. Lily may face some setback where Urban Butterfly Company may block Lily trademark registration application as prescribed in Section 24 and 25 of the Act. This may be illustrated by imagining that Urban Butterfly Limited presented an opposition claim to the registrar, and if Urban Butterfly Limited as the owner of the mark but was not satisfied with the registrar decision, the owner can bring their claim to the court for the hearing of their appeal. To mitigate this problem, Lily may try asking the owner of the trademark butterfly to allow the users of butterfly sign as part of her mark registration for the mark butterfly the bar. If not successful, she may have to wait for the registrar decision, and if she fails, she might fight the owner of the trademark butterfly for the usage of butterfly signs into her mark butterfly the bar. The judgment in the case of Saiful Bahri Muhammad against EM Exhibition Sedian Bahar and another may provide Lily with some leverage over Urban Butterfly Limited in the event the company brought the issue to the court for. To answer issue 3, Lily may encounter is other people might attempt to copy the mark of butterfly the bird adopted by Lily for her spray-on insecticide as her product brand label. In Issue 3, Section 159 applies on Lily, hence she may not sue the infringer of her brand on the ground of trademark infringement, nor she can hinder the attempt of such suit by the infringer. She may sue or request for the ratification of interloper trademark to the court on basis of passing of which she may invoke that the usage of her mark by unwanted party has causes misconception about her spray on insecticides products and confuse her regular customer with unwanted similar mark for her products. Judgment Women's Semua Sport Sedang Berhad against Menteri Sukan Negara Malaysia and Pelita Samudera Pertama Sedang Berhad against Vekata Sami anak lelaki Sumatiri on how should Lily bring her CV suit against the undesirable infringer of a butterfly debug marks. In conclusion, the marks butterfly, debug, and tripartite can be accepted and allowed by the trademarks divisions of the Malaysian Intellectual Property Corporation to be used as trademark for Miss Lily product in Malaysia as not identical to any company. The trademark butterfly debug may possess similarity with red-on butterfly mark used by Urban Butterfly Limited Company for their fashion products, but she is still registered to use the similar trademark because they both offering different goods, and we believe the consumer can distinguish between both trademarks. Moreover, the marks of butterfly debug will likely not cause any problem for Lily in the foreseeable future with Urban Butterfly Limited on the ground or similar trademark. Lastly, the trademark butterfly debug and tripartite follows the requirements and conditions specified by a relevant statute, with the mention to be used as legal trade name for Lily Company product established in the case. Thank you.
Assalamualaikum and hello. My name is Ani Sofia binti Anwar, matrix number 280902, and I will be presenting about the issue and rule or law that is required to answer question 2B. So the fact of this question is that Lily, who runs a business of a shrimp paste with a few of her colleagues or the locals, would like to apply for a geographical indication registration for their shrimp paste business. So it is said that the shrimp paste has special attributions and has its own spark and personality to it, such as the taste, the texture, the smoothness of the paste, and the aroma. It is also stated that the shrimp paste had built up quite a reputation and has even at one point been called the Kuala Sepagi shrimp paste. Other than that, the shrimp paste, the process of making the shrimp paste is also one of that differentiate that Lily's shrimp paste is different from others. And because of the higher demands in the market, that Lily plans to apply Kuala Sepagi shrimp paste for a geographical indication sign. So the issue arise here is pretty cut to the chase and self-explanatory as it is stated in the question itself, which is whether Lily's Kuala Sepagi shrimp paste will be accepted by my IPO for a GI registration. So there are requirements that had to be checked out the list before one is eligible for a registration of GI sign, which will further be explained in correlation to Lily's Kuala Sepagi shrimp paste by my colleague Naima. Now I will move on to the rules and law that defines and explains the definition, the general meaning of geographical indication, and what has to be known by Lily in order to apply this GI sign. What are the scopes of protection, for example, and the exceptions? So firstly, we're going to look at Section 2 of the Geographical Indications Act 2000. The geographical indication is described in this section as it identifies as a product that is originating from a province or country or area or territory where a given value, status, or attribution of goods is essentially to their geographical origins. So comparably, in Article 21's at Article 22(1) of the TRIPS Agreement, that the geographical area in the description of geographical indication in the Act I mentioned above just now While in the trip agreements only addresses that the territory, a region or a locality in the territory. So from these two agreement, from the slight distinction between these two wordings of definition in the phrase geographical indication, from both of the Geographical Indication Act 2000 and the TRIPS Agreement, it is established that the name of countries can also be a subject of geographical indication. So According to Section 27, Subsection 1 of the Geographical Indications Act 2000, the Act's defense extends to all the protectable geographical signs regardless of whether they existed prior to or after the Act's enactment. So there are no legal proceedings that will be commenced even if the mark is registered before the act begins. And next, Section 3 of the Section 3A of the Act states that the registration is not required to gain protection under the Act because it is provided that the Act offers the same degree of protection to all registered and unregistered geographical signs. This will further be explained by Naima. So, next, for the next section is Section 11(1) and Section A1 of the Geographical Indications Act 2000, which states that by person itself or through his agent, an application of registration of geographical indication may be made when A. An individual who engaged in a producer operation of geographical area specified in application with regards to the product specified in the application, which means that that individual engaged through the producer itself to apply this specific application for GI, for example, in Lily's case. And B, an appropriate authority, which is people that has been given the authority or the permission to help register. And C, a business organization or partnership. And in Lily's case is probably business, the shrimp-based business organization or partnership because she entered this business with the locals. So it's probably partnership. Next, the registrar will also review the application to ensure that the applicants has provided the details under Section 12 and that the geographical indications is not in violation of good order or morality. So obviously in Lily's case, it is a shrimp paste that she wants to register in GI registration. So obviously foods, in the category of food, it does not violate good order or morality. So next, provided in Section 19, subsection 2 and Section 19A, subsection 4 respectively, it is stated that a registered geographical indication covered for 10 years from the date of filing and is reversible for 10 years at a time. The registrar could, however, withdraw a registered geographical indication from the registry for a failure of renewal in accordance to Section 19A, subsection 7. So, what Lily has to know and keep in mind is that after registering for GI registration for the mark, the Kuala Sepagi shrimp paste sign, she has to always bear in mind that the duration is for 10 years, and after the 10 years, if she still wants to continue, then she has to not forget to renew it in the registrar, or not she might be eliminated from the registry. So that is all from me for my part, and now I will be passing this on to my other colleague, Naima. Thank you very much. Have a good one.
Assalamu alaikum. Hello, my name is Naima Khadijah Mohamed, admission number 275301, and I'm here to present the application. The GI registration by Lily is possible as long as makers carrying on their movement in geological region determined in the register will reserve the privilege to utilize an enlisted topographical sign throughout exchange. Lily will be able to register if she is an individual who is carrying on a movement as a maker in the topographical territory determined in the application concerning the products indicated in the application and incorporate as for such individual an able power or an exchange association or affiliation as in Lily's case. Notwithstanding whether the topographical sign is enrolled as against another geological sign which, albeit in a real sense valid, concerning the nation, region, area, or region in which the products begin, anonymously addressed to the public that the merchandise starts in another nation, region, district, or territory. The privilege of utilization be in regard to the items indicated in the register in an understanding to the qualified notoriety or trademark determined in the register. Lily needs to know that geographical indications are aggregate rights, making them an exceptional case as far as licensed innovation rights. Any broker who conforms to the standards and guidelines administrating the utilization of the GI is qualified to trade the GI to their products. As these principles and guidelines give confirmation to the purchaser in regards to the particular quality or standard of the item, makers should deliver their merchandise coupled with these guidelines to utilize the GI. Lily will also need to keep some points in mind, such as there are two significant conditions for the privileges of the utilization of geological science. Initially, just makers keeping up their action in the topographical territory determined the register reserved the option to utilize an enrolled geological sign in the exchange of business. Furthermore, the option to utilize the geographical sign should be in regard to the items itemized in the register in understanding the quality, notoriety, or trademark indicated in the register. Up to an extent, GI is substantial. Any items made inside the bounds of the entirety of the GI's rules on spot of beginning, item techniques, input materials, and so on will actually want to utilize the GI. In Lily's case, GIs are not normal for exchange, denoting that making a GI doesn't give the candidate sole rights to utilize the GI. All things considered, the GI can be applied to any qualified items. In any case, merchandise which doesn't meet the tough necessities of the GI can't utilize the GI imprints. This sort of encouragement misdirects the general population, accordingly falling under unreasonable rivalry and is deserving of orders, harms, and any other legitimate activities. That's all for my presentation. Thank you for your time.
Next, we move to question 2C. This question is pertaining to the geographical indication and its relationship with trademarks. There are three issues raised in the question. Firstly, whether Lily can apply for GI, geographical indication, to be refused for the registration or not. Secondly, whether the prior registration of the owner of the trademark can be cancelled or not. And lastly, whether the coexistence of both rights is established or not. First of all, I will explain about geographical indication, or I'll just say the acronym GI. GI is geographical expression used in relation to specific goods in the course of trade serve to identify the geographical origins of the good. GI is similar to trademarks in that both function as source indicators, but GI is not trademark. GI do not serve to identify a commercial enterprise as the manufacturing source of the goods. Instead, all producers of a product from the same region or locality are entitled to use the GI on their goods, provided that their qualities, reputation, and characteristics meet the standards set by the geographical indication owner. GI denote the area or region from where the goods originate, while trademarks denote the proprietor of the mark as the particular producer of the goods. In this case, in this question, the trademark does not have anything to do with geographical indication registered by Lily. According to Section 22, Subsection 1, Paragraph A of Geographical Indications Act 2000, any interested person may request the registrar to cancel the registration of a geographical indication on the ground that the GI is excluded from the protection under Section 4. Section 4 of the Geographical Indications Act 2000 mentioned 4 categories of GI that can be excluded from its protection. Firstly, GI which do not fall within the definition given by the Act. Second, GI which is contrary to public order or morality. Third, GI which is not or have ceased to be protected in their country or territory of origin. And fourth, GI which have fallen into disuse in their country or territory of origin. In this case, Lily does not face or have any of those 4 categories that can exclude her from the protection under the Act, so Lily's rights are still secured and protected. Lily may request to refuse the registration of her geographical indication only if she is excluded from the protection under Section 4. But since Lily is not, then Lily does not have to do it. So even if there is a registered trademark with the designation, therefore, Lily does not have to apply for the registration of her geographical indication to be refused. And this is for the first issue. Next, Section 28 of the Geographical Indications Act 2000 provides several exceptions to the rights to use a GI conferred by Section 21. One of them is in Section 28, Subsection 2, provides for the continued recognition of a trademark which is identical with or similar to a GI in certain situations. The subsection states that in the case of a trademark which has been registered or used in good faith, the validity of the registration of the trademark or the right to use the trademark shall not be challenged on the basis that it is identical with or similar to a GI, provided that the trademark was registered or used in good faith either before the commencement of the Act or before the GI concern was protected in its country of origin. This is in line with the first in time, first in right principle, under which pre-existing trademark should not be cancelled due to the subsequent registration of a foreign GI. In this question, in this case, the prior registration of the owner of the trademark can just continue the recognition of his trademark even though it was identical to the GI. The owner does not have to cancel it because if his trademark is registered or used in good faith, the validity of the registration of the trademark or the right to use the trademark cannot be challenged on the basis that it is identical with or similar to a GI. It cannot be challenged. As stated in this Act, the Act had already provided that the trademark was registered or used in good faith either before the commencement of the Act or before the GI concern was protected in its country of origin. Therefore, for the second issue, the prior registration of the owner of the trademark cannot be cancelled. And this follows the principle of first in time, first in right. In conclusion, Lily does not have to apply for the GI to be refused for the registration because Lily's rights are protected under Section 22, Subsection 1, Paragraph A of the Geographical Indications Act 2000, as she does not breach any provision in Section 4 of the Act. Next, the prior registration of the owner of the trademark cannot be cancelled because his rights are protected under Section 28, subsection 2 of the Geographical Indications Act 2000. Therefore, the coexistence of both Lily and the owner of the registered trademark's rights are established in this case, and that's for the third issue.